Hi, thanks for joining us today. We're talking about estate planning, legacy planning, which is ultimately how to keep your family out of court and out of conflict. Now, this is a serious topic, guys, and seriously, one of the most important topics you can consider. My experience takes me back 35 years as a financial advisor, a person who sits and has sat with countless families through the decades, sharing ways to help them manage, organize, and successfully transfer their assets to their loved ones. Unfortunately, I've seen the same mistakes over and over again. Assets not properly held, not properly titled, people in the family not knowing where things are during incapacitation or when someone dies. The amounts of money that are lost is incomprehensible over the long term, and families do lose money and assets through these transitions. So today, I'm going to be teaching you all how you can put an estate plan in place that will actually work when your family needs it. Again, thanks so much for just being here with me today, because I really wanted to spend a little bit of time with you about this important subject. Now, to get the most out of our time together, it's important that you turn off all those distractions and keep them at bay. So if you're one of those types of people that has 1,000 Google Chrome tabs open, honestly, put aside all those distractions and hone in right now, because you really do deserve this time for yourself and ultimately for your family. And at the end of the day, when we talk about estate planning, wills, trusts, powers of attorney, those words. When we talk about estate planning, the reality is that estate planning is not about you. It's not. It's not about you. It's about the people you love most. Because your loved ones, they're going to know how well your plan is working or not working when that time comes. And this will be helping families. We will truly help you create a plan that will actually work when your family needs it, and one that keeps them out of court and out of conflict. So what you're going to learn today is if and when something happens to you, and you know that it will, what actually happens next to your loved ones. We're going to explore this from two different perspectives, the before perspective and the after perspective. Now, the before perspective is all about what happens to your family if you have no estate plan in place, or only a document here or there, or maybe an outdated plan that has been looked at years ago for when that sad day occurs, and you're either incapacitated or you're no longer around. We're going to see just how vulnerable your family will be and the problems that they'll have to go through. And then there's the after perspective, which is all about how a personalized, tailored estate plan can solve all these problems, like keeping your family out of court and out of conflict. Now, through the years, we've experienced many families who have put together estate plan consisting of trusts, powers of attorney, living wills, advance directives, and making sure that they properly titled their assets. And they pay big money to have these estate plans completed. Currently, we're seeing estate plans sold for about $5,000. The national average could be between $3,000 and $5,000. Now, I am not an attorney, but I do have experience and can act as a facilitator, coordinator to help you do what you need to do to get a properly written estate plan in place by working through a network of attorneys that draft the documents, oversee the plan itself, prove it for suitability, compliance in the state in which you reside. So firms in the past that handle estate planning would draft the documents, change a few asset titles here and there, and then set their clients on their merry way. That's all well and good for that one transaction. However, during life, things change. As we know, people get married, divorced, have children, change their locations, fall in and out of love, and change beneficiaries. Also, they gather new assets. And what fails to happen is that these new assets do not become part of their estate plan. So 10 years from the original date, their estate plan is really not valid because those assets will go through probate. So that's a real shame that took place. After these firms would complete estate plans, they would never follow up with the client throughout their life to ensure that the docs are being updated and keeping pace with changes that occur in the client's life, let alone the changes that were occurring in the laws. No, they were not creating an inventory of the client's assets to make sure that all assets could actually be found by the family after the death or incapacity of a loved one. So guys, literally, there's over $2 billion sitting in the Florida Department of Unclaimed Property right now for this very reason. Because when a person dies, the loved ones you actually leave behind can't find all the accounts, and that family's assets go lost forever after someone passes away.
It's not something we like to think about, but one man is sharing his story, hoping you do.
Yeah, he says that after losing his mother last year, he learned that he'd have to spend hundreds of dollars to make sure the money in her account stays with the family. Here's NBC6's response, Elena Machado, with what he wishes they had done before she died.
Rochelle Arthur lived the last 20 years of her life here in South Florida, taking her final breath on Halloween of last year at the age of 86.
I think she might have been tickled that she passed away on Halloween for some reason.
Her only son, Adam Lapidus, lives in the Northeast, but says he stepped in to help his mom as much as he could, especially toward the end of her life.
I had access to her bank account and, took care of all her bills.
But that access suddenly stopped when Rochelle died.
After a few days of just dealing with everything, I, went back onto her bank account and found out it was locked out and I couldn't get any information. So I called Wells Fargo and they said they found out she passed away and they locked out the account.
Adam was not a co-owner or a designated beneficiary on the account. Still, he was surprised to learn he'd have to hire a lawyer and potentially spend hundreds of dollars in legal fees without knowing for sure how much money was left.
I thought it'd be like, hey, let us know who you are. Send us our death certificate, prove that she's passed, and we'll send you the money. That's what I thought it would be. I was very wrong.
In an email, Wells Fargo told us Florida requires a court order to disperse funds in a sole-owned account after the owner's passing, adding, once we are notified that a customer has passed away, we secure the accounts to prevent unauthorized use. Online banking access is also disabled.
You have to think the whole system is designed to prevent fraud. It can't just be the first person that gets their hand on a death certificate, gets the money that's in the account.
Probate attorney Candace Palti says she frequently hears from people facing a similar situation.
There's only so much you can do once somebody has passed away to avoid it. The better thing to do is planning during life.
That includes making sure your accounts have a designated beneficiary. You could also add a loved one to an account as a co-owner. A will could also help, but
he would have to go to court and he'd have to have the will admitted to probate.
Adam doesn't think there's enough money in the account to make it worth spending hundreds of dollars to get, so the funds will eventually end up with the state of Florida as unclaimed property.
Which infuriates me. That's not where it needs to go. It should go to her grandchildren.
The state tells me it typically takes 5 years for funds to end up as unclaimed property. And once that happens, you would need proof of death and a probate court order designating the legal heir, or a will or a trust that establishes you as the beneficiary in order to claim the money. A spokesperson also says they recovered over $800 million this past fiscal year, and many of the accounts they received did not have a beneficiary.
Is this something you want to see happen to you and your family? Who is it that you feel should be protected from this kind of thing? Why don't you type in the chat box right now? Who is it that needs your protection? Who is it that needs your protection? Seriously. Who are the people in your life right now at this very moment that needs your protection? I'm curious to see what you have to say. Yep, absolutely. Yep, absolutely right. Children, wife, kids, absolutely. Family, spouse, yep. Absolutely agree. Grandkids. Great. So you've learned how a traditional estate plan that you may have gotten years ago at a traditional estate planning firm can tell your family they're all set. But I want to expand on that by taking you to a few other scenarios where not having a plan in place or a complete plan and how that can fail your family also. And I want to explain these important estate planning concepts by taking you through a few series of sad days of a fictional cartoon character family that is comically called the Bliss family. So without further ado, let's say we go ahead and meet the Bliss family. Now, this beautiful family, guys, got Mark, Molly, Alexander, Benjamin, and Caroline. Now, Mark and Molly, they're happily married with their lovely home here, and they got 2 wonderful kids. Benjamin is 12, and Caroline is 10. And Molly, she also has a child from a prior marriage, and that child is Alexander. We're dealing with a blended family here. Now, between Mark and Molly, husband and wife, they got joint checking accounts, and they're putting money away in retirement like a good family, right? They both have life insurance and make sure there's financial resources if one of them were to pass away. And they both came into the marriage with a little bit of savings already and each have bank accounts, and Molly has some inheritance money from her parents who recently passed away. Now, as I mentioned, before her husband Mark, Molly had a prior marriage. She was actually married to a college sweetheart named Xavier. Xavier and Molly had a son, Alexander, who's now 15. And Xavier was that kind of wild, fun, crazy guy in college that never really settled down and got serious as a husband or a father. So Xavier and Molly eventually got divorced. And as a result of that divorce, Molly has primary custody of Alexander, and Alexander lives with his half-brother Benjamin, half-sister Caroline, and the stepdad Mark. Now, after their divorce, Xavier updated his life insurance policy. I mean, he obviously didn't want his $1 million life insurance policy payable to Molly, who's now his ex-wife, right? He wants it payable directly to his only child, his son, Alexander. So Xavier made Alexander the designated beneficiary of his life insurance. And that's a good thing, or isn't it? We'll see. So like I said, Xavier made Alexander the designated beneficiary on his life insurance policy. So really, it's just your everyday family right now. But you know, this poor family is going to be put through the ringer because they're gonna have to go through quite a few sad days in a really short period of time for us to learn more about estate planning together. So I hope you'll bear with me, guys, because the Bliss family is about to be put through an absolute train wreck today. As a quick side note, I hope you can get a sense of how I approach this topic of life and death. You know, I don't take myself too seriously. I do enjoy humor. I'm not trying to be insensitive or offensive in any way. I just want to make sure that I'm actually painting these really important points in a manner that you can easily understand and educating you in the process. Now, with that being said, we're going to jump right into sad day number one. And sad day number one, Xavier, the party animal, Xavier is turning 40. This is his big birthday, guys. So what does he decide to do? He decides to go skydiving. Yes, skydiving. He jumps out of the plane, but the parachute doesn't open. Adios is Xavier. And Xavier has no estate plan in place. Although, remember, he did do one responsible thing in his life. He had the life insurance. Yes, he had the life insurance, and he named his minor son Alexander the designated beneficiary on his life insurance policy. Now, while Xavier thought he was being responsible, you're about to see how all this caused a lot of problems. Now, remember, Alexander is only 15. He's a minor. I mean, hey, he's a teenage millionaire on paper, right? And he's really excited about this fancy red Ferrari he's about to buy. As you can see over there to the right is his mother, Molly, and she's very concerned about this, very concerned. So she says to herself, well, wait a minute, that's $1 million. That's a lot of money. Can he legally be in charge of that money at the age of 15? I mean, how can I help to make sure he's responsible with this money? So Molly calls and quickly learns some bad news. She's going to probate court. Quick side note, what is probate court? All right, guys, follow me. When a person dies owning assets still in their personal name, probate court is the court process of transferring the ownership of those assets out of the person's deceased's name and transferring the ownership of those assets to a person who is currently living. In other words, if you die with assets still owned in your personal name, then your family has to go through the probate court process in order to legally get ownership of the asset that you leave behind. But another reason people have to go to probate court, like in Molly's case, is that of minor children. Whether they're 5 months old or 15 years old, they cannot inherit money directly until they reach the age of adulthood at 18. So Molly has to go through a court process to determine who is going to be put in charge of the $1 million until Alexander turns 18. And next, for the bad news, I got to tell Molly here that she's not necessarily going to be chosen by the court to be put in charge of that money for Alexander. Oh yeah, that's right. You see, as part of this process, we have to submit Molly's credit report and criminal background check to the probate judge, which Molly considers a bit invasive, but she has no choice because the judge is going to want to see all these things and make sure that Molly is a responsible person in the judge's eyes to manage $1 million for Alexander. And well, guess now who also shows up at the probate court asking to be in charge of Alexander's money? Right, Xavier's brother Zachary. Yes, that's right, Zachary. Now Zachary is telling the probate judge, hey, hold on a second. I'm Xavier's brother. This is Xavier's life insurance money, and I doubt Xavier would want his ex-wife Molly to be managing it. He would want me, his brother, to manage it for Alexander, and Molly's telling the probate judge, now hold on a second. While I may be Xavier's ex-wife, this $1 million insurance money is supposed to go to Alexander, and I'm Alexander's mom and legal guardian, so of course I should be put in charge of my minor child's money. So here's a question for you, and type in the chat box right now. Who do you think the judge will choose to manage the $1 million for 15-year-old Alexander? Is it going to be Molly, Alexander's mom, or will it be Zachary, Xavier's brother? Go ahead, type that answer in the chat box right now. I'm curious to see what you have to say. Yep. Okay, I'm seeing mom, mama, ex-wife. Okay, so yeah, an overwhelming amount for Molly. Well, here's the thing, guys. We don't know. We don't know. It's really going to be up to the probate judge. There's no legal requirement that the judge needs to pick Molly just because she's the surviving parent and legal guardian of Alexander. And there is no legal requirement that the judge chooses Zachary just because he's a blood relative of the deceased person to whom the insurance money is coming from. And whoever that judge appoints is going to serve until Alexander is 18, because then he becomes an adult. Now, what did I just say? Because then he becomes an adult at 18. Well, wow. So suddenly we have an 18-year-old kid, Alexander, in charge of $1 million with no oversight whatsoever. Now, can you see how this might cause problem? Him dating models, taking beer trips to Thailand, backpacking through Europe for a couple of years, putting off college, starting a rock band. This is no good. So yeah, let's do something better for this Bliss family. Now remember, we ran into problems. Xavier made his minor son, Alexander, the designated beneficiary of his life insurance policy. So let's see how we can fix these problems. Now, here's an idea that Xavier decides instead to designate his brother Zachary to be the beneficiary of his life insurance. Let's just give the money directly to brother Zachary. It's everything that's needed, right? This is a quick, easy fix. A lesson learned here: don't name a minor as a beneficiary of life insurance. Well, here's the big takeaway on this, guys. Never do this either. Never do this. And here's why. Look, you never want to name anyone as a beneficiary on your life insurance or retirement account money that you wouldn't want to truly receive the money without any restrictions attached. Xavier doesn't really want his brother Zachary to receive the money. He wants his minor son Alexander to, but if Xavier makes his brother Zachary the designated beneficiary of his life insurance just to avoid the probate court, then the life insurance becomes Zachary's money. It's just that simple. And if brother Zachary wants to use that $1 million, that money for the son, Alexander, great. But if Zachary wants to use it for himself, great, because Zachary gets to decide, because it's Zachary's money now. Look, guys, even if brother Zachary is a trustworthy person, since Zachary owns that money in his name, that money is now at risk of being taken away from Zachary if he ever got into a future divorce lawsuit or dispute with a future creditor or business partner. And that's why it's a bad idea for Xavier to name his brother Zachary to be the beneficiary of his life insurance, just to avoid the issue of probate. And the second idea we have here is that Xavier signs a will, a last will and testament, saying, "This I leave everything to my son Alexander, and if he was under 21, I put my brother Zachary in charge." Well, that sounds reasonable, right? Hey, everyone says you need a will, so everything's going to work out just fine with that idea, right? Well, not really. There's a big hole in that plan, guys. I think it's going to surprise you. Xavier did not know that joint ownership and beneficiary designation will override your will. This is a big one in a plan that a lot of people miss. I really want to make sure I break this down and describe it in some detail. I want you to think about this concept in 3 separate buckets, okay? Joint ownership, beneficiary designations, and your will. Now, here's the thing. When someone calls me after a loved one has passed away, the first thing I want to know is whether their loved one who passed jointly owned any of their assets with anyone else. Now, I'm not asking whether or not they had a will, because you see, if the person who passed away jointly owned anything and the other joint owner is still living, then that surviving joint owner is going to get that asset regardless of what the will says. So in Xavier's case, let's just say Xavier remarried. Now, before he remarried, he was the sole owner of his home. After he remarries, Xavier adds his new wife to the title of his home. Now, Xavier and his new wife jointly own their home together, as many spouses do. And when Xavier created his will, if he really just wanted everything included, including the home to go to his son Alexander after he died, then Alexander will not get the home in this scenario because Xavier's new wife is the surviving joint owner of the home. She will get the home even if Xavier's will says, I leave everything to Alexander. And that's how joint ownership overrides Xavier's will. Now, if assets are not jointly owned, then the next thing I would ask is, okay, well, what are the beneficiary designations saying? Guys, I'm willing to bet that you have beneficiaries designated at this very moment, like on your own life insurance policies and your own retirement accounts. And if the designated beneficiary is living like Alexander is in our case, then Alexander is going to receive that $1 million life insurance money outright, even as a minor, even though Xavier has a will saying otherwise. And this is because beneficiary designations will override your will. And now we're back to probate court. because a minor is inheriting insurance money. You see, this is where that traditional one-size-fits-all form document estate planning law firm or the self-online estate planning software that Xavier used didn't tell him about this. Now, Xavier is rolling in his grave. Of course, there are any assets left over after we go through joint ownership and beneficiary designation. Discussions around whatever assets that are left over go into Xavier's probate estate, and it is only at this point at the probate estate where Xavier's will comes into play, because his will controls who will get whatever assets fall into his probate estate. And if Xavier did not have a will, didn't have an estate plan at all, then the state's intestacy laws will control whatever assets fall into his probate estate. This is the biggest myth we could just bust right here today, that a will, a last will and testament, does not avoid probate court. If you die with a will, your family will still have to go through the probate court process, and the judge is going to have to interpret it. And that probate court process in Florida by law takes a minimum of 3 months on average, but can take anywhere up to 9 to 36 months or even longer. And it can cause your family up to tens of thousands of dollars by the end of it. It's also 100% public information that can be looked up online. It's also just not a fun process at all for your loved ones that you leave behind, especially when they just want to grieve the loss of you in peace rather than dealing with a legal mess if you're gone. So I'm sure you're wondering right now, well, what do I do if I don't want my loved ones to have to go through the probate court? Well, here's our idea number 3, where Xavier gets a revocable living trust instead. And guys, we're just going to call this a trust right now for short. And in this trust, Xavier says, I leave everything to my son Alexander, and if he is under 21, I put my brother Zachary in charge. Well, it sounds like we just said that before. Well, that's true. We're saying the same thing that he said in his will. So how does this work? Well, first off, there are so many different types of trusts out there which serve a lot of different purposes, but the type of trust we're talking about right now is a revocable living trust, which serves the purpose of avoiding the probate court. In other words, how can I say who gets what, under what circumstances, and make that happen, but not have to go through probate court? So why don't you just think of the revocable living trust as a will substitute, in that it's like a will, but it doesn't go through probate court, and that's why it's called a will substitute. Now, here are the 3 buckets in the context of a trust. So we go through the joint ownership and beneficiary designation discussions, and we have specific steps that we take for each of your assets. We don't just stop working for you just because you've signed the trust document, because then we need to take steps to fund your trust or put into your trust each of your assets one by one. And guys, when we say put assets in your trust, we mean literally transferring the title of ownership of your assets out of your personal name and transferring the ownership of your assets into the name of your trust. So your trust owns the asset. And for some assets like your home, we're going to update your title from your name to the joint names and marriage name, and then to your trust name owning the home. And yes, if you're in Florida, there is a way that you can maintain homestead status when you do that. For other assets like life insurance, we're actually going to update beneficiary designations from, say, your minor child to name your trust as the designated beneficiary, and then there is no probate anymore. Of course, another thing, if you have a mortgage on your home, you can put the home into a revocable living trust. So there is no probate estate anymore, right? Because everything you own is in the name of your trust that you control. So when you die, you own nothing in your personal name, which means your family does not have to go through a 9 to 36 month probate court process and pay up to tens of thousands of dollars in costs just to get ownership of your assets. And in fact, because a trust is private, they can get ownership of your assets in a matter of weeks. Now, long story short, a trust just makes things way easier on your loved ones after you're gone and allows them the time to focus on grieving your loss, and so that they can heal rather than having to deal with a long, expensive mess in probate court. So I also like to describe a trust kind of like a red wagon. You know, just like when you were a kid, you could put your toys into your red wagon and have full control over the wagon, carting it around. You can take your assets that you own out of your personal name and put them into your trust and have full control over that trust. So that way, when you pass away with all of your assets being owned in the name of your trust and not owned in your personal name, there's no need for your family to go through probate courts. So again, as long as your trust is funded, meaning all of the toys are in the red wagon, all of the assets you own are in your trust, there's no need for your family to go through probate court to get these assets. So here's a way to describe a trust. Look at the scenario, guys. Look at the scenario. All of the toys here are outside the wagon. And here's what's happening in this case. You signed a trust. Now, whether that was in an attorney's office or something you bought online, your trust legally exists. You signed it, created it, but your trust is that empty wagon. All of the assets still owned in your name when you die and not owned in the name of your trust means your trust is not going to avoid probate court in this scenario. Guys, this is a huge danger with using a do-it-yourself online estate planning tool that are out there. some traditional one-size-fits-all form document estate planning firms. Now, to bring it back to Xavier, here's a much better scenario. All of his assets are inside the Red Wagon, and Xavier gets a revocable living trust, and he names the trust to be the primary designated beneficiary of his life insurance policy, not his minor son Alexander. And Xavier names his brother Zachary as the trustee of Xavier's trust, who would immediately be put in charge of all the funds for Alexander's benefit after Xavier dies. Plus, since Zachary wouldn't personally own the $1 million in his name, the money is now safe and protects against future lawsuits, creditors, and divorces. And best of all, no probate court was necessary to make any of this happen. No court, no conflict, no delay. So this is the longest lesson of everything, because I really wanted to make sure to explain and have you understand the difference between a will and a trust and how they operate. Now, the next few lessons, they're going to go by much quicker, but the biggest takeaway from this one is that a review of how you own all your assets must be the biggest part of your estate planning conversation. Just having one document here or there, it's not going to be enough to protect you. So why don't you go ahead right now and type yes in the chat box if you want to avoid this very costly and long drawn out probate court process for those you love. Go ahead, type yes in the chat box if that be important to you. Absolutely. Yep. I can see the chat here firing up. Yep. Absolutely critical. Absolutely. 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 Yep. Yep. Absolutely. Great. Yep. Let's move on to segment number 2. It's going to be a fun ski weekend for the Bliss family now. They're going to be heading out to Vail, Colorado with their family friend Dina for a long ski vacation. Dina doesn't have any kids of her own, but hey, she loves Alexander, Benjamin, and Caroline just like they were her own children. And the vacation starts out great, but unfortunately, fog descends on the mountain very quickly. Mark and Molly, who were skiing downhill really fast alongside each other due to the fog, and before you know it, Mark and Molly now crash into each other, and now we got a skiing gone bad situation. Mark and Molly, they're incapacitated. They've been airlifted down to Denver Hospital many miles away. Meanwhile, their friend Dina gets word of Mark and Molly's accident. Well, she has to drive to the ski school now to pick up Mark and Molly's minor kids and take them to Denver Hospital. And at the same time, Dina is freaking out. She's calling Molly's sister Mindy in Texas to tell her what happened and what's going on. Mindy's freaking out. She's calling Delta to schedule a plane ride up to Denver to be with her sister Molly and her nieces and nephews. Dina, well, until Mindy can get there, I guess Dina will just take the kids and look after them in the meantime, right? Well, wrong. Dina can't take the kids. Dina gets the kids at the ski school, but the teachers, knowing that both of the kids whose parents have been airlifted to the hospital, are forced to call the police until a legal nominee guardian can come forward and take custody of the kids. So when Dina's at the ski school to pick up the kids, the police asked her if she's the legal guardian of the kids and if she has any paperwork to prove it. Dina tells the police that she's a longtime friend of the family, and the kids know her and the kids trust her and they want to go with her. Sadly, the police have been informed that the children need to be taken downtown and placed in the care of strangers and Child Protective Services until the kids' legal guardians can come forward or be nominated by a court. Guys, this is a major problem. If Mark and Molly could communicate, they would say, please let our kids go with Dina. We totally trust her, but they can't communicate. They're both incapacitated in a coma in the hospital. They have no will in place or any other documentation that nominates legal guardians for their kids either. So we're stuck in this no man's land wondering how long it's going to take the courts to choose legal guardians for the kids. Look, if you're a parent with minor children, this is going to be one of the scariest scenarios you can ever consider. Can you imagine how scary that would be for a small child that goes through this? All right, so let's do something better for the Bliss family. So put together a short-term guardian nomination document for Dina, and where we have Mark and Molly nominate temporary guardians like Dina to be able to act as first responders and quickly arrive on scene in emergencies to take legal custody of the kids temporarily until the parents can get out of the coma. So that way your children are always with exactly who you want, no matter what. And of course, guys, copies are given to Dina, including electronic copies of the legal documents. So Dina could just pull up the short-term guardian nomination document on her phone, show it to the police, and allow them to let Dina take the kids with her in an emergency situation. So Mark and Molly finally have a plan that actually works when their family needs it to. And the big takeaway, guys, lesson number 2 is that guardianship is about who would raise your kids until they're 18. For those of you with minor children or even minor grandchildren, and you want to protect them from being taken by strangers to Child Protective Services in this type of an emergency, why don't you type yes in the chat box if that'd be important to you? Go ahead. If that's important to you, to make sure that your children are protected and you have a guardian in place should something happen to you or a grandchild, go ahead and type right now yes in the chat box. Yep. Absolutely important. I agree with you. Yep. Very important. Yes. Absolutely. And so we move on to sad day number 3. Mark makes a full recovery from the ski accident, but Molly, unfortunately, she's still unconscious in the ICU, and Mark is making Molly's medical decisions for now. But then Mindy calls the doctors. She wants to get an update on how her sister Molly is doing, but the doctor can't tell her anything, he said, because he has a big red stop sign called HIPAA. The doctor can't talk to anyone about Molly's medical condition without Molly giving explicit permission in writing to do so. Now, up to this point, like I said, Mark has been making Molly's medical decisions alone. But after Molly's sister Mindy arrives, both Mark, the husband, and Mindy, the sister, legally get to make these medical decisions together. Now, you may be thinking to yourself, why? Why? Mark's married to Molly. He should have the exclusive right to make Molly's decisions. Well, that's not a big surprise, right? Well, no, he doesn't. The law says person or persons can make medical decisions for someone who's incapacitated when there is no estate plan in place. So this means that Mindy and Mark are now on equal playing field when it comes to making medical decisions for Molly. So what happens if Mark and Mindy reach an impasse on Molly's medical care? What happens then? Well, the doctor is going to have to tell them, sorry guys, but you're going to have to fight this out in probate court. Again, we're back at the probate court. Another family is stuck in conflict. And then at that probate court proceeding, Mark and Mindy would have to litigate before a probate judge about who should have the right to be Molly's legal guardian with the sole legal authority to make medical decisions on Molly's behalf. But before we even get to court, Mark's trying to keep up with the medical bills as they pile up. So he actually goes to Molly's bank and tries to make a withdrawal from Molly's savings account to help pay her medical bills. But the banker says Mark cannot access Molly's savings account because it's in Molly's name only. Mark's not an owner on the account. Remember, Molly had some money in there prior to their marriage and just never got around to adding Mark to the account. But Mark told the banker, but hold on a second, I'm Molly's husband. Same with the medical decisions, guys. It doesn't matter. It doesn't matter. Now, this may sound crazy, but Mark is going to have to go through probate court to prove that he is capable of making Molly's medical decisions by himself and that he is a responsible person capable of handling Molly's finances by himself. So here the judge is going to choose Mark, the husband, or Mindy, the sister, to manage essentially Molly's affairs. Hey, when it comes to those finances, Mindy herself wants to do that. Well, hold on another second. This is the inheritance money from my parents in that account. I don't want Mark to have it and make bad decisions with it. And she's making this very clear to the judge. And Mark, he's just really annoyed with the whole thing. He's just like, well, of course I'm a trustworthy person. Of course I have Molly's best interest in mind. We're married. I'm her husband. Why can't I have access to this account? This is such a big hassle. But again, we're back at the probate court again because that's what the law says you got to do when someone's name is not on an account. Even if they're married or when somebody doesn't just specify in advance who does get to make medical decisions for them. So it was an absolute nightmare for the Bliss family, guys. So now let's do something better for them. So prior to this ski trip, Molly calls to find out how she can protect herself and her family from probate court and at the same time make sure that the people she trusts and intends to handle her affairs will be able to do so without a judge's decision if she's ever incapacitated in the hospital. And she decides she wants her husband Mark as her medical power of attorney so Mark can make Molly's medical decisions alone, even if her sister Mindy is present. So now, even if Mindy and Mark came to an impasse on Molly's medical care, Mark legally has the final say, and we don't have to go to court to fight about that. But Molly gives her sister Mindy a HIPAA release, so Mindy can call the doctors, and the doctors are allowed to tell Mindy what's going on with Molly's medical condition. And Molly also signed a financial power of attorney document that named Mark as a sole decision maker regarding her finances, and he could walk right into the bank and access Molly's savings account to pay her medical bills. So the big takeaway, guys, here, lesson number 3, is that the only other person other than you who can make decisions is a probate judge. And having these documents in place lets you specify in advance who does get to make these types of decisions for you. So let's go ahead and type yes in that chat box if you want your healthcare and financial decisions honored by those that you love and not ending up in the hands of some stranger judge. Why don't you type yes in the chat box if you think that'd be important to you? Yep, absolutely important. Critical. Yep. Critical. Yep, absolutely. Yep, absolutely. Yep. And as we move on to sad day number 4, unfortunately, the doctors ultimately had to deliver the bad news to the Bliss family now. Molly, in the judgment of those 2 doctors, has the irreversibly internal injuries with no chance of recovery. And the only reason she's still alive is due to being on life support. Wow. So who actually gets to make this call as to when to remove her from life support? Well, that'd be whoever the probate judge has selected as your medical decision maker, right? And whoever that person is will be making a complete guess as to how long you would want to hang on. I mean, can you imagine? No one wants to be in that situation, and you never want to be the one that puts that decision on someone else's shoulder. So as you can imagine, guys, there's going to be a lot of different views here. I mean, maybe husband Mark says, well, look, I know my wife, I know Molly, she would not have wanted to remain this way. We have to let her go. But maybe her sister Mindy says, slow down, Mark, slow down. Wait a second. I know my sister. I know a miracle can happen. And she would want us to wait until that miracle happens. Mark, we cannot just let her go. So what are you talking about here? So now a decision of when to terminate life support is going to have to be decided as a group. And after a lot of arguing, bickering, accusations, and tears, poor Molly's ultimately removed from life support and does pass away. And Mark and Mindy, they never speak to each other again. So let's do something better here again for this Bliss family. Instead, Molly, before the ski vacation, creates an advanced healthcare directive in our estate plan, otherwise known as a Florida Living Will, where she states exactly how long she wants to remain on life support before she wants to withdraw. And so now there's no more decision by committee, and the family is kept out of conflict. So the big takeaway again here, guys, lesson number 4 is that you want your loved ones to stay out of conflict if you're no longer around. Then you must act now if that's what you want, before it's too late, before something happens. Because when something happens, it's a done deal. When the law says about what your family has to go through at that point, it's a done deal. Your family can't just go back and rewind anything. They're just going to be stuck with whatever you did or didn't do. And as we finally face our final sad day, number 5, Mark never remarried, and many years later, even Mark passes away. Because even after everything he went through with Molly, Mark still delayed getting an estate plan in place. He just couldn't bring himself to do it. And so he never got his estate plan done. So when he passed away, his kids get a call with more bad news. They're in their 40s now, and the bad news is they're going to have to go to probate court again. Probate over Mark's estate, because when Mark died, he owned his $500,000 home and his $500,000 money market account still in his personal name. Remember, if you own anything in your personal name when you die, then your loved ones have to go through the probate court process in order to transfer them in their name based on who your will says to give your asset to, or if you don't have a will, who the state law says to give your asset to, who the government says to give your asset to. So instead of being able to grieve their loss of their father Mark in peace, the 3 adult children are now going to be stuck in the next 9 to 36 months or longer in probate court after he died. So now that we've covered just how much time it's going to take for Mark's children to go through the 9 to 36 months of probate court, let's look at how much money this is going to cost Mark's children by the end of it. Now, when you add up all the fees that are involved in a probate court proceeding, from attorney fees, executive fees, bond fees, court costs, appraisal fees, etc. Now, in Florida, state law says that just a probate attorney's fees alone, not including all the other fees, just a probate attorney fee in Florida alone is 3% of the fair market value of that probate estate. So let's see Mark's estate value to begin with. What's its value? Well, any asset that was still owned by Mark in his personal name when he dies is his probate estate. So in our case, that's his $500,000 home and his $500,000 money market account. So the total value of his probate estate is $1 million. Times it by 3%, and you get that probate attorney's fees alone are at $30,000 that his children will have to pay for the probate court process. And by the end of probating Mark's estate, after we pay off any of Mark's outstanding debts and after we pay the $30,000 to $50,000 in probate costs, whatever is left over from Mark's estate goes to each adult child outright, meaning they're going to own their inheritance in their personal name, repeating the same dreaded process because there are no restrictions or protections in place. Look for the sheer fact that you're all here right now on a class like this, taking yourself and family seriously. It tells me that for those of you with children, you're probably some of the best parents out there. Seriously, you actually care. In fact, I'm sure you give your kids opportunities, and maybe you have grown them up, getting them into the right schools, getting into PSCT prep, getting them into college. You've been putting them on the right path, right? You've been putting them on the path for success. And that's all well and good. That's in your control as a good parent, but because it's all the other stuff that's just not in your control. Like, look, you guys can't control who your kids fall in love with, right? I mean, we raise our kids, we instill values, good values in them, and we hope that through that, they're going to pick the right mate for themselves, even to pick the right one. People just change later in life, don't they? Just like that, for no rhyme or reason. So what happens after both of you are gone? Your kids inherit your money, and then they get into a divorce. I mean, you really, would you be happy without the 50% of the inheritance you left behind for your children that you worked so hard for going to your ex-son or ex-daughter-in-law? I mean, it's not out of the question with 50% divorce rate in this country. And if your child was ever facing a lawsuit or bankruptcy proceeding, those lawyers and banks can take anything on your kid's personal name. So how do we face these concerns? How do we face these concerns? With proper estate planning. How do we make sure that Mark's 3 3 adult children do not have to go through a 9 to 36 month probate court delay and pay $30,000 to $50,000 in probate costs and then receive their inheritance outright where it's at risk of being lost if they ever get into a divorce, lawsuit, bankruptcy. How do we do something better for the Bliss family? So before Mark died, we helped him set up a revocable living trust so his children could avoid the probate court after he died. And we also put all of his toys into his red wagon, transferred all of his assets into his trust. So that way, when Mark died, his home and his money market account were in the name of his trust, and his 3 adult children received ownership of those assets in a matter of weeks. No more 9 to 36 months of probate court and no paying the court system $30,000 to $50,000 in probate costs. And instead of having the kids receive the money from Mark's trust outright in their personal name, we're going to have the kids receive their inheritance in the name of their own lifetime asset protection trust that they are their trustees of. So that way, your child's inheritance is protected from any future divorces, lawsuit, bankruptcies, and the heirs protected. The big takeaway here, guys, lesson number 5, is that after you die, your kids will not be able to create this lifetime asset protection. Only now, while you're alive, can you give your children the gift of lifetime asset protection. So let's go ahead and type yes in the chat box right now if you want your children and heirs protected from any future divorces, lawsuits, and bankruptcies. Go right now, type yes in the chat box. That'd be important to you. That's right. Yep, absolutely. Yep, thank you. Yep. It would be. And a quick bonus lesson before we start winding things down. Your family will really appreciate the fact that you stopped with your busy lives and you realized there was never going to be a perfect time to get this done. So instead of trying to find the perfect time, you simply made the time to do this, made the time to get an estate plan in place that kept your family out of court and kept them out of conflict. Your family is always going to appreciate the fact that you just made the time to do this for them, convenient or not. But look, at the end of the day, what they're really going to want for the rest of their lives is something to remember you by, right? Your legacy. Because I'm not just talking about the money. I'm really not just talking about the money. What I'm talking about is your intellectual, spiritual, and human assets. Okay, who you are and what's important to you. I mean, it's about your loved ones having your insights, your values, your stories, and your experiences. It's a way to remember you so that you can transfer your intellectual, spiritual, human assets to your loved ones. Guys, why is this important? Candidly, I don't have any videos, audios, or written words from my father. I only have 2 photos. I never knew him. A massive heart attack took him away 36 years ago, and all his knowledge, wisdom, and life experiences, they're gone forever without proper closure. Children and families need closure, and you can provide that gift to them today, this great gift, closure. I really hope you make time to do this for them. So look, there's a lot here, right? I mean, there's a lot that I shared with you today that will create a positive impact on your life and the lives of your children and family. The first step is the hardest to correct. The fact that you realize you haven't prepared, you have stuff everywhere, and unless you organize it, the state and government will. Do you want that? I don't think so. And if you don't want that to happen to you or your family, right now, go ahead and type in the chat box. Say you want to have a 15-minute easy conversation, and go ahead right now. Type 15, the number 15 in the box, and I'll follow up with you, and we can help create your life's plan together. Thanks for joining me today. I had a lot of fun. I hope you did too. But more than that, beyond that, I hope you learned something that will stick with you for the rest of your life. Take care now, folks.